So welcome everybody to our, to what promises to be a really interesting discussion, which we will start with a keynote from Cornelia Woll. Rules that sort of police global companies are almost everywhere at this moment, with directives and laws from the EU in particular seemingly coming through almost every week. There's a lot of discussion about this. And of course, this has a history. You know, it's not obvious how you make sure that that global companies comply with laws, given that lawmaking and also enforcement is national. But Cornelia has written a book about this, which has the history of it, and it also and the theory of imposing laws on global companies. After that, we will have a discussion with experts from business, from international organizations, and also the civil society sector. I'm really looking forward to this, but I think, let's give Cornelia the floor, and I will present the panel after that. Cornelia, we're very curious about your book, which is called, by the way, and I love the title, Corporate Crime and Punishment.
Yes, thank you very much. I'm trying to see, can you see a whole screen or? No?
I think you're showing us the presenter view, Cornelia, and if you have two screens, maybe you want to switch.
Does it work now?
It is, well, I mean, it doesn't matter, but it is the presenter view. So usually you should have an option.
Let's see.
Zoom. You just have to pick when you're, you say share screen, and then you have to, yeah, that's perfect.
Good. Thank you very much for the nice introduction, Nicola, and also for the invitation. And just so that everybody can situate where I'm coming from, I'm a political scientist. I'm not a legal scholar, and I've been working on business government relations for quite some time. And I wrote a book that I'll talk about just now, which started with what to me was puzzling, and that is the diagnosis that Nicola just put out. There's a lot of constraints now weighing on companies that are active in global markets. And to a certain degree, that is surprising to people who have worked on global economic questions, because when I was in university, there was this idea that somehow companies are very mobile and they are in some form of impunity beyond the reach of, in particular, domestic law. And the assumption was that that is the case because a lot of activities, in particular criminal activities, are a matter of national sovereignty. Companies are mobile, and they would be able to just move or escape the reach of the jurisdictions that might want to go after them. They can also do regulatory arbitrage, and they're just very important players in the global economy. So sometimes for a government, possibly also for the legal system, it is delicate to go after a company if that means losing a lot of jobs or losing a lot of growth potential. And so to a certain degree, back in the day, the assumption was that corporations are in some form of impunity. And I think the starting diagnosis or the recognition is that that is no longer true. There's a lot of cases where you can see very big companies becoming embroiled in legal battles. And I was struck by this when I researched the aftermath of the financial crisis, but also other areas, and asked myself, well, why do companies no longer escape these legal sanctions when they're active in global markets? And there's a lot of answers, a lot of elements that could answer this question. But what I focused in my book in particular is the way in which domestic law and global markets are connected, and the way in which power structures how exactly companies evolve in the system. So my book, Nicola just introduced it, is called Corporate Crime and Punishment. And it makes an empirical argument that I want to present up first. And then I will walk you through some of the findings. And then I would like to open it for discussion, because I talk very little in this book about multilateral institutions and rulemaking in multilateral organizations. And we have a lot of experts here in the room that do, and I think it's important to open it up, but I'll start just by throwing the ball in the air from the domestic law perspective. What I would like to argue about the way in which companies are no longer beyond the reach of law is an argument that focuses in on the United States in particular and the Department of Justice above all. I will argue that we have to understand the very specific set of evolutions in the United States in the way in which companies are prosecuted for criminal activities, so corporate criminal activities. And in particular, in this context, the way in which settlements can be reached between a prosecutor and a company independently of whether they are actually brought to court or to trial or not. So you can go after a company and negotiate these settlements. And that has allowed the US lawmakers to expand the extraterritorial reach of domestic law, because their markets are a relevant reference point to the companies that they are in negotiations with, and the Department of Justice can withdraw, for example, an operating license to a company, so has the possibility to push companies to engage in negotiations with a prosecutor that are actually outside of courts. And this mechanism allows American law to develop an extraterritorial reach that previously wasn't as powerful. And that means that the US Department of Justice has legal reach over companies and global markets in ways that these companies now have to deal with. And that puts the governments of the other governments in a delicate spot, because it means that they might have a US lawmaker going after their companies outside of the jurisdiction of the US and highlight, for example, criminal activities that the home country didn't even go after. And so they're either failing their own oversight, or they're discovering that their companies can become a play ball in global markets. And the push for this is to reach agreement between countries about harmonized rules or tools that can be shared by everybody, so that they can gain their judicial sovereignty back in a way that feels more equitable. That's the story I'd like to tell. So it's a political story, and it focuses on what I've just described, the rise of negotiation in global markets, or what I call then the negotiated corporate justice. Corporations are no longer in this world of impunity, but what they are in is a world that is much more negotiated than a real trial-based police activity that we would have expected maybe in a national domestic setting. Okay, that's the empirical argument. Let me walk you just through some numbers and developments so you can actually see what I'm talking about. This is data that comes out of a registry called the Corporate Prosecution Registry. So these are cases prosecuted at the federal level, but they're not just cases that are brought to trial. They're also cases that include these settlements. They're called deferred prosecution settlements. And they give you an indication of the fines that are, the punitive fines that are reaped through this process. So, for example, when the Department of Justice goes after Volkswagen in the emissions scandal, or when BNP Paribas is fined almost 9 billion for sanctions violations for activities in Switzerland, all these cases can be in this database. And you see that at the beginning of the century, so 20 years back, there were a number of cases, but didn't have as much of a fine attached to it. And you really see an upward move, fewer and fewer cases, leading to more and more fines on all sorts of areas of corporate criminality. So some of these cases are antitrust cases, some of it is fraud, securities violations, sanctions violations, corruption cases, pharmaceutical and other. So this is a whole group of different areas. Maybe we want to focus in, but I just wanted to show you the overall development. What I was also interested in, and this is the geopolitical part, of it is that you see the Department of Justice going after companies, and look at the bottom line that I'm showing you here first, that are from different countries. So the domestic, the home market of these companies in the majority of cases is in blue. Here is, of course, the United States, because one would expect that the American Department of Justice goes after American companies for corporate criminal activities. And this is the case in about 85% of all of the cases. But when we look at who pays the most important fines, we don't find the same distribution. The fines that the American companies that are being prosecuted end up paying in all of these cases in the registry accounts for a little over 40, I think it's 43%. And there are a lot of other cases from companies that come from abroad that account for a significant amount of fines. So I'm not saying there's a problem by showing you this. There might be many reasons that explain this bias, but bias already indicates there's a problem. That explains this discrepancy. But what I am saying is that for the number of cases that concern foreign companies, once they're prosecuted at the US federal level, the amount of fines that are at stake here, and these are, we're in the billions, makes a significant impact. And that is why the governments of these companies have at one point asked themselves, why are $4 to $5 to $6 billion going into the Department of Justice for corporate criminal activities that either we might have prosecuted at home, or that we feel are unjust, or that we feel are political? What exactly explains this, this discrepancy? And I can tell you more of what the companies are thinking about this as well. Now, I tried to look at this by doing data analysis, which is very difficult because I don't have, for example, information about the exact amount of the criminal activity at stake. You would expect that a fine, for example, sanction, punitive fine, corresponds to the damage done in the criminal activity. I don't have this information. I don't even have the information of how big the company is through whatever indicators. The only thing I can measure is for what type of crime did a company pay what type of fine? And is it a public or privately held company? So public means it's a publicly listed company that's on the stock market, or is it, for example, a company that's in family hands? And if you compare, for example, the publicly listed companies, so these are all very big companies, and you look at the different type of criminal activities, what you do find is that the likelihood of being fined increases by almost 15% if the company is of foreign origin, so non-US companies. And these non-US companies, once they're being prosecuted in the US, also pay fines that are 6.6 times larger. Again, I'm not saying here that that is discriminatory, but I'm saying it is something that needs to be explained. Once you're a foreign non-US company that is prosecuted by the Department of Justice, not only are you much more likely to being fined, you're also more likely to pay a much higher fine. So why exactly is all of this possible? Because to a certain degree, the governments of the companies in question here say, why is the Department of Justice from the United States going after our companies? And the mechanism through which this is possible, the power structure here, is something where what matters is not the jurisdiction in which you're in, but it's the effective jurisdiction. Who can really claim that they have jurisdiction over you, and by what mechanism? And that effective jurisdiction depends on market infrastructures. Are the companies that you are prosecuting reliant on infrastructures provided by your country and therefore governed by the domestic law of your country? So, for example, is the company listed on the New York Stock Exchange? If the answer is yes, then US security regulation applies, and then the US has jurisdiction. Does the company use a settlement system? Does it pay in dollars? Is it doing transaction that goes through US banks? Does it use data that is US based? All of these different elements provide nexuses that can give the US effective jurisdiction. But that doesn't mean much if it can't enforce this. In order to enforce sanctions or settlements, what is also necessary is the power of the market. You need to have the possibility to withdraw access to an important market for you, for the company. So just imagine I am the US prosecutor. I have a very important company that is a multinational company in discussion with me. And I can say, if you do not help us do an internal investigation, you might lose your license, you might lose part of your activities. That creates a very strong incentive for the company to cooperate with you in an investigation. If you're Luxembourg, you don't have that tool at your disposal. So market power and market access are important to enforcement. And this is something that, of course, also the pundits have noted in this little joke where Credit Suisse, once it reached a settlement with the US Justice Department, said we have saved what matters most, and that's the banking license. And of course, the joke here is it's the bonuses of the board, but it's the incentive system of cooperating that I wanted to highlight here. When you have prescriptive jurisdiction plus market power, you can create this effective jurisdiction, which is extraterritorial. Now, the long arm of American law has developed in this manner in very different domains and for very different reasons. In antitrust, this has gone through the impact on the domestic markets that it can, the Department of Justice can effectively argue happens, and the Europeans do the same. In securities trading, it's the stock exchange, same for foreign bribery. In economic sanctions, very often it's the settlement systems, et cetera, et cetera. There's different nexuses, but they help us to see why in certain areas we have a global police. And you see this here in the total payments made by foreign firms, and in other areas we don't, or enforcement is much more lax. One very global area is the oceans, for example, and when ships pollute the oceans, it's normal that this is something that is a global problem that needs to be addressed, but it's also something that's not as heavily fined. You can barely see it on my pie chart, whereas antitrust, fraud, and corruption, import and export is sanctions violations are areas where we see a lot of these extraterritorial phenomena. We see much less of it in environmental crime, for example, and my intuition would be that that might change in the future. Okay, I don't want to be too long. What I simply want to say here is that this created, maybe let me, before I have all countries here, this created a real challenge for governments. Because if it's the Environmental Protection Agency of the United States going after German automobile producers for emissions manipulation, it sheds a very poor light on the German government that just seems complicit with German automobile producers. And all of a sudden people are asking, why was Germany sleeping at the wheel when there was all these all this manipulation going on? So if you have extraterritorial reach, you have competition over judicial oversight. And for many governments, it's quite important to regain judicial sovereignty. And it's also important to show that they are able to address corporate malfeasance. It's quite often argued that governments shy away from going after corruption, fraud, or other corporate criminal activities in their own country because they do not want to touch companies that are an important source of economic development. If you can see that there is criminal activity going on because somebody else does, then all of a sudden governments have to show that they can move as well. And that has led, with the US taking the lead, to a lot of innovations in the legal instruments that governments gave themselves. So the US negotiated agreements that I refer to, these corporate, deferred prosecution settlements, were slowly adopted in other countries in a process that one may call a diffusion. So in 2013, the United Kingdom adopted, in particular in bribery and corruption cases, a deferred prosecution agreement, even though it was quite foreign to the UK. 2014, Brazil tried to adopt something similar called a leniency agreement. Legal change happened in Spain, also in France. In France, it's called judicial agreements in the public interest. But France also created a specific tribunal, so a parquet financier, which actually was able to prosecute corporate cases. And just for the discussion, I'll say that there was a lot of discussion in France on whether these negotiation instruments are even legitimate in a civil law tradition where something is either right or wrong. You don't negotiate like you would in a plea bargain, for example. So it's quite foreign to the legal culture. And back in the day, the argument by those pushing for it was to say we need to do this in order to be able to get a hold of corporate criminal activity, which otherwise will go across borders or be prosecuted by the US. So there's an argument of it's maybe not a good solution, but it's the best we have. And this created a split also in the civil society organizations fighting corruptions, with particular Transparency International France being quite favorable to having one instrument that worked, and other organizations such as Sherpa saying that it is illegitimate to go for an instrument that is a negotiation instrument, and they were quite opposed to it. So in every country that is listed here, there's a lot of arguments about these legal instruments. Some in the end ended up adopting them. Mexico in 2018, Argentina, Canada, Japan, Peru, Singapore. The fact that they adopted them doesn't mean that they use it a lot. Canada is an interesting case in point because they've adopted it and they've immediately decided never to use it because they had a corruption scandal that was very closely linked also to accusations against the government. And it was felt that this instrument wouldn't be put to good use. So you have change in legal instrument, but not an actual use of it. But the story I want to highlight simply by showing you this diffusion is that the drive of one country, the United States, to use a tool that was quite effective creates institutional change and legal adaptation elsewhere. Which brings me to what I would like to have as my final point. I'm trying to show a general development where really global markets create a dynamic of competitive transformation of how we prosecute corporate criminality. So I call this the transformation of corporate justice. But the question is, what exactly is corporate criminality? How do you prosecute it? For example, is there such a thing as a corporate entity that can be criminally liable? That's a discussion that is relatively new in some countries. And the trend I see is driven here as a trend towards a more negotiated modality of trying to go after corporate malfeasance. And this negotiation approach is more effective than what has happened in the past, where you sometimes found yourself not being able to prosecute these activities. But it has a certain number of biases because some companies can negotiate better than others. Some cases are more easily dealt with than others. So there is, it is not the right or wrong categorization that we expect from the legal system, but really how exactly these things can play out between the lawyers on both sides. And that may create a risk for democratic legitimacy as well, because if certain companies that can, because they have tools in the negotiations that help them get away with criminal activities at a lighter rate than others, or what one would expect if you're looking at it as a citizen, then the idea is that people can buy themselves their innocence back, that not everybody is equal before the law, and that can create a sentiment of injustice within countries and with respect to global markets. So that is a risk. And that is why I think it is extremely important to see that multilateral organizations try to harmonize standards once we see that we need to address a certain issue. That is precisely what the OECD has done through the Anti-Bribery Convention, to not have one country uphold its norms unilaterally, but to say what exactly do we need in order to come to a shared norm of prosecuting or going after corruption, in this case, anti-bribery. In other cases, it might be other failures, because the challenge is to have a global police that is driven by those who can, the most powerful. It'll be based on their own norms, and norms are very important in criminal activities, because criminal activities really are about standards of what is right or wrong. And these are, everybody I think would agree, sometimes locally quite different, and it's not something that you can easily import from somewhere else. So there has to be a place where these norms are discussed, where everybody can come together and say, this is the red line where we agree everybody should be held accountable. Other things may be a little bit different. And so to a certain degree, I'm telling you a story that I think can be solved, but that creates a lot of tensions in the global economy and also means that there's a potential for abuse with tools that are very effective, but that can be used more effectively against outsiders, foreign companies, rather than domestic companies. And I think that's also a world which we would like not to have. So I will stop here and I'm looking forward to the discussion. Thank you very much.
Thank you, Cornelia. And this was really a great introduction into the world of, well, enforcing laws in a global market. And we now have a super expert panel, I almost want to say, to really carry on and take this discussion a little bit further. So Cornelia just mentioned the OECD Anti-Bribery Convention, and we have Nicolas Pinault here, my colleague from Paris, who basically leads this work. Welcome, Nicolas. We have more Nicolas here. We have Nicola Alocca, who comes from the business side. He leads the Anti-Corruption Committee at Business at OECD, which is the business association that really watches, so an international group of business associations that watches OECD work and also shapes it. And he also represents Autostrade Italiana. Welcome, Nicola. We have, and now I really didn't follow the ladies first rule, but I'll catch up on that. We have Gillian Dell, who's from Transparency International, which was also mentioned, an important organization that has for long been instrumental in imposing or in fighting for corporate integrity. And then we have, last but not least, Anna Maja Mertens, who represents a group of German companies that have come together to figure out how they can basically comply, how they can further compliance, not only with anti-bribery, all others are mostly in the anti-corruption integrity business, but also other rules. So welcome to my panel. And I think now that we've talked so much about the US and its market power and how its activities basically led to changes in other countries' laws, I think I would, like to play that back to you, Nicolas, so the OECD Nicolas, because, I mean, in preparation to this meeting, I also read that in developing the OECD Anti-Bribery Convention some 25 years ago, in fact, the US was instrumental. And you also mentioned last time we discussed this, that the convention relies very much on the structure of US law. So it would be interesting to hear a little bit how was basically the US mostly at the initiative of getting together countries to have this OECD convention, or is it also other countries that thought, well, now that this is happening, other countries basically prosecuting my companies, let's get together and build the rules together. How did this convention come about?
Thank you, Nicola, and good afternoon, everyone. And I want to thank you, Nicola, for organizing this webinar, and also really to congratulate Cornelia for a great presentation, which I think is really spot on many of the issues that we are dealing with the OECD. And by the way, not only on foreign bribery, but if we think of tax, typically, the same kind of issues came up, and we had to deal with those issues as well. So indeed, as you said, Nicola, let's take a sort of step back. When the US adopted the Foreign Corrupt Practices Act, the FCPA, in the late 70s, it was a major step forward. It was the first country to really criminalize foreign bribery. But in the 80s and the 90s, the US felt that their own companies were actually at a disadvantage compared to other OECD economies, which didn't have the same laws and which were not going after foreign bribery offenses by their own companies. So in a way, the level playing field was still to be built. And therefore, they pushed in two directions. First, they pushed to have a similar provision, somehow mainstreams at the OECD level, that indeed, as you said, led in the 90s to, first of all, the setting up of the working group on bribery at the OECD, and at the end of the 90s to the adoption of the OECD Anti-Bribery Convention in 1999. So that was the first direction. So to make sure that the US law would actually make its way to the multilateral level, and that all the OECD members would abide by the same rules, so that companies would basically operate on the level playing field. But the parallel track, if I may say so, was they also sometimes push for an aggressive extraterritorial enforcement of the FCPA. So they had two tracks in a way, the multilateral, but also the unilateral with like I said, aggressive extraterritorial actions. And this is how basically the WGB came about. And the good thing is that in a way, the FCPA has been really a catalyst for change, including at the multilateral level. Like I said, it led to the creation, the setting up of the WGB. It led to the adoption of the convention and obviously to the enforcement of the convention. And this OECD convention is today really a very strong and perhaps the only international instrument that is focusing on foreign bribery, to the supply side of foreign bribery. And it had an impact. We are this year celebrating the 25th anniversary of the OECD Anti-Bribery Convention. Of course, not everything is perfect, but Gillian knows that. Transparency International, while pointing to the limitations of the implementation and the enforcement of the convention, also dubbed the convention the gold standard in the area of foreign bribery. It's not for nothing. And if you look at the numbers, the working groups enforcement data, this is a reflection of those efforts. By the end of 2021, over 925 individuals have been sanctioned, 675 entities, so corporations, in fact, have been sanctioned for foreign bribery and related offenses. So this convention had really teeth on the ground, if I may say so. And like I said at the start, the FCPA really played a key role in being a catalyst for change, including at the multilateral level.
Yeah, thank you, Nicolas. And Gillian, I think, so one thing I wonder about, because you really watch this, right? And you're critical in terms of, well, whether these conventions work, whether perhaps also the US law works. But what I would like to hear from you, perhaps, is it really the case that it's mostly the US that has been driving this, well, also the possibility to come to negotiate multilateral standards, or are there any other countries who also try to, well, make sure that that there's no impunity for corporations, or perhaps it's not possible because they're not big enough? Just from your perspective, what are the countries that help you most, that help you as a civil society organization, make you happy in a way, because they really push for rules that are effective?
Well, thanks very much, Nicolas, and thanks for the invitation to join this panel. And also thanks to Cornelia for this thought-provoking analysis. I'm looking forward to reading the book. It's a very interesting angle on the challenge of law enforcement in a globalized world and the challenge of tackling cross-border corruption. As you said, I'm coming to the subject primarily from the angle of foreign bribery enforcement, and we at Transparency International have been promoting national enforcement against global companies engaging in foreign bribery. This started with our advocacy for adoption of the convention and of other international legal instruments which call for criminalizing foreign bribery. And we do congratulate the parties to the OECD Anti-Bribery Convention on the 25th anniversary. We've been promoting since then implementation and enforcement of the convention, including through our reports on country performance. And those reports show which countries are doing the most enforcement, which is the best way of supporting holding companies to account that are bribing in foreign markets. Unfortunately, the level of enforcement, according to our records, the last report we did was in 2022, has been declining. And I would say that from the outset, it was one of our main partners in promoting the OECD Anti-Bribery Convention and other conventions criminalizing foreign bribery was the US, but other countries have come on board since then and have been working to improve the national and international legal framework. And one that comes to mind actually, where there have been quite a few innovations or developments that have been very helpful has been the United Kingdom. Many of you who know this field know that they passed the UK Bribery Act in 2010. After some foot dragging, it has to be recognized, and they introduced a failure to prevent offense, which was novel and different from the US Foreign Corrupt Practices Act. And they also introduced important sentencing guidelines for corporate offenders in fraud, bribery, and money laundering cases. And the UK also made a very important contribution to tackling foreign bribery by emphasizing that it's not only in the interests of economic development, of a level playing field, which is oft cited, but that it's in the interests of economic development and economic justice. And it gave expression to that in the 2018 General Principles to Compensate Victims in Bribery, Corruption, and Economic Crime cases. So shifting a little bit the focus from merely, again, the level playing field or free competition argument to looking at the harm done. That's something we're also very concerned about. And we're just another thing the UK has done, which we think has been very significant, has been that it's spearheaded the creation of the UK-based International Anti-Corruption Coordination Center, which brings together specialist law enforcement officers from multiple agencies around the world. I'm quoting from their website, to tackle allegations of grand corruption. And they do this by improving fast-time intelligence sharing and assisting countries that have suffered grand corruption and would like support. And this is very important to evening out the role, the enforcement role among different countries, making it possible for countries perhaps with weaker enforcement systems to actually carry out an enforcement function. We heard concerning other countries, France has really stepped up in recent years. Cornelia mentioned the Parquet Financier. They also passed the Loi Sapin 2 in 2016, which requires preventive measures for large companies, risk management, and possible sanctions for the lack of effective compliance programs, which again is different from the US model. Canadian remediation agreements introduced in 2018 in principle introduce a greater focus on victims than in other countries in that sort of agreement in non-trial resolutions, although it remains to be seen how that's going to be implemented in practice. And just one more example, in Switzerland, the NGO Public Eye has triggered foreign bribery enforcement by filing complaints. And I think that role for NGOs stands out in Switzerland, and indicates that within this process, NGOs can play an important role also in triggering enforcement in their countries. But, you know, there's still, what we found is, unfortunately, that in many countries, there's still a lack of adequate enforcement for whatever the reason, which is negatively affecting the landscape for international compliance.
Yeah, thank you, Gillian. And I think now I would like to turn to the other Nicola this time, because Nicola, you are basically engaged as a business representative, also at the international level at the OECD, in order to promote integrity, anti-corruption. And I think you've even spearheaded a program that's called the Zero Corruption Manifesto. So I would like to hear from you a little bit. So what's the rationale for business to get engaged there? Is it mainly the the concern for level playing field? And where are we from your perspective? What's the progress? Where do we have to go further?
Thank you very much. Thank you for having me today. And it's truly an honor to be part of this distinguished panel. And congratulations to Cornelia for her presentation and her book that I look forward to read too. Businesses need to develop a long-term vision which considers both planet challenges and opportunities. In this regard, corruption is the challenge, but zero corruption is the opportunity. It is clear that we need an urgent action plan, and we could call it a switch to growth. It can strengthen the real economy in this volatile, uncertain, complex, ambiguous, liquid, and modern world. And the business at OECD, as you know, is a network of over 10 million corporations in over 55 countries, and it is a leading institution in the fight against corruption. And as chair of its anti-corruption committee, I feel a great responsibility. And I think that we all have a solemn duty in fighting this global cross-cutting issue. We must face it together to assure a sustainable future and progress on long-term challenges. In this regard, I would like to draw your attention on two numbers, 2024 and 0. 2024, this year, is a critical year in the fight against corruption. As Nicolas Pinot said, the Anti-Bribery Convention is turning 25. And this could be an opportunity to change our way we think about corruption. And this brings us to the second number, 0. 0 is a value, 0 has a value, and 0 must be a target as zero corruption. There is a European Parliament study calculating the impact of corruption on EU GDP. According to the numbers, if we eliminate corruption only in Europe, we can eliminate hunger, provide drinking water globally, and assure healthcare standards to the poorest countries, and we still have additional resources left. So if we allow corruption to deprive the next generation of key resources such as education, healthcare, security and safety standards, environmental rights, social wellness, we will inflict an intolerable burden of inequality on our children. For this reason, we must have the courage to admit that it is possible to eliminate corruption and to give this target its proper dignity in the UN SDG agenda as a new SDG. Now, in order to translate this commitment into action, we have issued a manifesto that calls for the treatment of zero corruption as an 18th SDG. It is a multi-stakeholder paper that can be applied by public and private organizations, corporations, and business representatives. And the manifesto puts forward the 10 key actions to build a more resilient, sustainable, responsible, and corruption-resistant global economy. These actions are organized in 3 main clusters, which represent the essential dimension of our Race to Zero. In the first cluster is changing the way we think about corruption. This means that we have to break biases that corruption cannot be eliminated. This means that businesses should implement anti-corruption measures with the aim of eliminating and not just reducing the corruption risks. Probably this is one of the reasons because we have a lot of fines. The second cluster is creating meaningful tools and taking impactful measures. It includes stimulating responsible conduct, incentivizing and protecting brave voices, promoting freedom of press and vigilant media, and adopting tech for trust and transparency. The last cluster is acting together globally, and here collective action is vital in order to build a resilient and sustainable business ecosystem with zero corruption. So in conclusion, the manifesto forges an alliance between us and those who will come after us. Thank you.
Thanks a lot, Nicola. Before I go to Anna Maja, I think I would come back to you, Cornelia, because one thing I've been pondering about while we were speaking, so now we heard that business is very engaged in promoting a zero corruption agenda, but in terms of your political science theory, you were making the point that market size and market power is very important for a country to be able to sort of impose its rules globally. Now, this seems to have worked quite well with the US and then the OECD. So with countries basically that have not, you already pointed to problems with having different legal systems, but still it's countries that like to think of themselves as being like-minded and democracies and rule of law, etc. But now that, other countries perhaps with another approach, other values are becoming bigger in the global economy and we have more tensions, I was just wondering how would it play out when this is more conflictual, when a country arises, let's say, where others would say, well, I can't follow because I don't agree. But still the country has some power in order to impose rules. So in this geo-economic conflictual state we're in, what can we expect?
Well, I'll make it relatively short. I mean, the mechanism I described is a mechanism that concerns countries that are allies and companies that want to be mobile in these different markets of like-minded countries in particular. And can I also answer the question you first asked to Nicola, but why are companies interested in moving forward on this? Because if there is no harmonized standard, it's a free-for-all. And we have even issues of double jeopardy where you might be prosecuted in one country and then in another country for exactly the same crime. And that, of course, creates a level of uncertainty that companies will find very difficult if they're moving across markets. So it's important that we get an harmonized standard, but you say quite rightly, that means we can agree among like-minded countries or friends on at least some very basic norms. And the risk I see is that that is most likely not going to happen when there is big rifts. And the main trend we see in global markets currently is that global markets are fracturing again, and that the geo-economic world I just described will break along these same lines. I'll give you the example of sanctions violations. Sanctions are, of course, mechanisms that go through companies and our foreign policy. You express a sanction against Russia, the companies have to make sure that they don't violate the sanctions, and if they do, they'll be prosecuted. That means that back in the day when, for example, Europe and the US did not exactly have the same line on Russia, some European companies were trying to still build Nord Stream 2, but were exposing themselves to being prosecuted by the US. So you have to negotiate whose foreign policy is most important for you. Once everybody agrees, that's easier. But think of the case of Huawei. Huawei was embroiled in a lot of legal battles in the US. And of course, the answer is in order to steer away from this, maybe they just want to be active in their home market. But if they don't, then we have to agree on what standards should be the legal base, and we're very far away from this. So I'm not entirely optimistic that we can stay clear of a world that is fracturing across geopolitical lines.
Thank you, Cornelia. So yeah, let's come to Anna Maja, because basically you're the managing director, Anna Maja, for a group. So we have it in your back. We can see Deutsches Institut for Compliance. So it's a group of German companies that are, well, trying to work together to be compliant on different dimensions. But this thought, so how difficult is it to think about this with an international lens in order to be compliant everywhere, also comply with European laws that have a reach beyond European borders? What are the challenges here?
Yes, thank you so much, Nicola, and thank you for the invitation and the fantastic presentation, Cornelia. And I'm already, by the way, reading the book, so I'm ahead of you. I have it in my bedroom. Yes, exactly. That's sort of. We are sort of, our members, we have more than 1,000 members, are mostly companies that are committed to compliance and not just sort of fulfilling the regulations, but also going beyond to seeing what is our responsibility. And this is basically what we do all the time within the organization. And the main persons that we are speaking with in these companies are the chief compliance officers, and for the major companies, but also the minor companies. And that sort of the challenges in major companies are very different for the minor companies. And basically, these chief compliance officers are fighting two battles at the same time. They have this internal battle, and then they have the external battle. In the terms of the internal battle, they need to convince not only the managing board, and that's in normal cases because they need to be committed in order to become a member at DICO. They have to sign the contract. That's not the problem. But to get each and every staff member to be convinced and not just doing the sports of avoiding regulation, trying to find loopholes. And in order to manage this, you need to show the sense behind the regulation. So they need to understand how come this is important, not only for the others outside this company, but especially, particularly for our company. And that's huge. And it's at the moment, you said that already, Nicola, it's a tough task at the moment because there are different things that they are really missing at the moment. And the most important are you need to have some kind of political predictability. You need to know what is coming next. And we have in Germany some cases that, for example, we had this criminal corporate law that was actually already there. And it was withdrawn very sudden because of some political argumentations. But of course, if you hear that in major companies, as soon as you hear it will come, you need to go and restructure your whole procedures. So it's a very cost intensive, and you need to sort of prioritize that because of course you have then a deadline when it comes into force. And then there is this clarity, what counts. So to someone to explain what are the regulations that have to be implemented by us. And that's not always so easy to say because we have several, like the due diligence in supply chains, we have the national regulation, European regulation, and there are very, very many questions. And the best chief compliance officer or the most committed just do not know what counts. So I think it's very important for the companies that there is no room for different interpretations. So there's accurate or adequate, and they have all these kind of words. What does this mean? So this is the internal fight. But of course, there is also this external fight because they need to be active with the ones who are making business outside. They are all the time accompanying them, saying what are they allowed to do and what not. And then we have this situation that the companies see their responsibility not only fulfilling the regulation, implementing that, but also going beyond. One example is Ukraine, the situation in Ukraine. We are all, I think in individual level, but also in this corporate level, trying to find out what is my responsibility in this context, how can I support? And this counts also for the companies. And they see that, of course, if you just see the normal German compliance levels, you cannot sort of use that or adapt that to Ukraine, because then you have the Russian operators there, and to see what is, if the context is not safe, if there are very many risks, is it wanted that the companies do not go there, or shall they go? What kind of do's and don'ts can we create for that context? Because what we saw, and maybe the last remark, what we saw in some African countries from the German perspective is that because there were just too many red flags, they withdrew all the activities, concentrated their activities in different parts of the world. And who came in? The Russians and the Chinese companies. And is this something that we want? Or shall we do something about that? And I think this kind of dialogue between, because there is not just one business and one politics, one civil society, but there are different actors. But I do believe that in the context of companies, there are so many companies that are really willing to do the right things and the things right.
That's actually a good point that I would like to pose to perhaps Nicola and Gillian, because Nicola, and I don't know whether that's the case for the anti-bribery convention, but I know for our OECD M&E guidelines, which are basically also the standard underlying the recent EU law on supply chain sustainability, let's say, CSDDD, we have this notion of stay and behave rather than withdraw. So you should do everything, even if things are not perfect, you should, as a company, well, make sure that you can do whatever you can do to improve the situation, be it human rights, be it environmental impact on the environment, but not withdraw. But in practice, this can be very complicated if the governance is not good in that country. So how is it with the anti-bribery convention? Is there a similar notion, and is it something you're discussing in the group? How to act in different contexts because in some countries the governance may be good, in others a bit less. So what to do there?
No, that's a very good point, but maybe I'd like to pick up on a couple of things if you agree, Nicola, because it's also supposed to be a dialogue. Responding to perhaps a couple of things from Gillian, I think, okay, we can see the bottle half full or half empty when it comes to the implementation and the enforcement of the convention, but there needs to be a recognition that if you take the 46 parties of the convention, they all have foreign bribery as an offense, which was not the case indeed 25 years ago, that the non-tax deductibility of bribe is actually in force in all those jurisdictions. So there has been progress. I mean, the convention has been really a catalyst for change. It's true that on enforcement, there is still some way to go, and we know that half of the jurisdictions have yet to prosecute and sanction one single case of foreign bribery. So still a long way to go, but I think that really the convention had a major impact on transforming the legislation in the 45 parties to the convention. I put Russia aside. Responding to your question, Nicola, this is precisely the role of the Anti-Bribery Convention, to also be a catalyst for change at the level of corporations. It should be really, because if business indulge in foreign bribery practices or offenses, normally the 45 parties to the convention should have in place the legal framework and the resources for enforcement that will enable those jurisdictions to go after those businesses. So this is in principle a very strong incentive for corporations to put in place the relevant compliance systems. And before it was mentioned the UK Bribery Act, it was also mentioned the Loi Sapin 2. It was part of those legislation to precisely require from corporations to put in place also robust compliance system. At least it was in particular the case of the Loi Sapin 2 with the setting up of the Agence Française Anti-Corruption, which is actually the AFA, which is actually checking the robustness of compliance system in corporations. So the first response on the supply side is that corporations should put in place a risk management system, compliance systems, to have the ethics and deontological frameworks in order to deal with solicitation. So that's the first aspect. Where, in fact, indeed, there is perhaps a weak spot for the convention. This is the demand side. How to deal with solicitation. This is something that is actually tackled under not the convention, which is entirely focused on the supply side, but in the 2021 anti-bribery recommendation of the OECD, which complements the convention, which indeed is providing some, let's say, some guidance to companies when it comes to dealing with solicitation. But there, I think we need to go further. We need to also to help the business to deal with solicitation. We need also to talk to governments on the demand side. And this is also why it's important to enlarge and to broaden the membership of the working group on bribery, so that we have also in the group jurisdictions which are more on the demand side of corruption. So we have to work on this aspect as well. It's really a dynamic process. And this is part of the equation. Another important aspect which Gillian mentioned is victims. I think this is an aspect which is not sufficiently tackled in the working group on bribery. And this aspect of victims is quite frequently also at the heart of the concerns of other non-OECD jurisdictions. So how the victims are compensated for foreign bribery offenses committed by multinationals from OECD members. That's an important aspect that the WGB should probably take better into account going forward.
Well, that's the perfect effect prompt, of course, for you, Gillian. And I would like to hear your opinion on this, but also perhaps a bit more broadly, stepping back. I would like to know, how difficult, how do you see this increasingly fragmented world? Is it getting more difficult to impose or to fight for integrity? And also linked to that, because we talked a lot about OECD countries, but Nicola mentioned how much harm can be avoided if we go to zero corruption, and that of course plays a very important role also in Asia, in Latin America, in poorer countries. So I'm wondering, and we talked about victims, are there some countries from other parts of the world that are coming up with innovations, with good ideas, with how you address the demand side, how you go about finding international agreement? That would be interesting to hear.
Thanks for that. But I just want to say I do agree with Nicholas that there has been progress thanks to the OECD Anti-Bribery Convention by all means, and also that we should help countries and work with countries on the demand side. That OECD Convention countries should do that. And I mean, actually, one channel for that I mentioned already is the IACCC, the International Anti-Corruption Coordination Center, which offers precisely that possibility where those demand side countries are interested, where they're what we call willing but not able, so they lack the capacity. We also see that potentially business can be an ally in this area because business working in international markets is equally affected and adversely affected by corruption and by failure to uneven enforcement, let's say. And we actually, speaking of the issue of victims and the harm, we very much welcome the Business at OECD guide on linking anti-corruption and human rights compliance systems, because they are very much connected. And what we do see, I mean, speaking of fragmentation, there has been fragmentation for a while, so it's not completely new, but I suppose the countries that are not on board, at least not fully on board with tackling, say, foreign bribery, like China and Russia, have not been on board for quite a long time, but I guess their role in foreign spheres, the foreign markets has increased, and therefore we worry actually that unwillingness of theirs to enforce is affecting the commitment potentially of OECD convention parties. We hope not, and we encourage them not to be influenced by that, but that could have an effect. Just in terms of picking up on something Anna-Maya said, which was about the company need for predictability. We link that to this whole development that Cornelia has highlighted with non-trial resolutions, actually. And we do see those non-trial resolutions as a problem in the way that they are currently being used. And a particular aspect of that is the lack of transparency in many countries. I think that our business colleagues will agree that transparency of outcomes, of enforcement outcomes, is absolutely crucial for them as well as for the wider public in order to ensure fairness and even-handedness in the treatment of companies. And, you know, this, and also, of course, that also applies for that judicial review is also a crucial element, which is also missing in many countries. So we would hope that our business colleagues would be on board for strengthening what was included in the OECD 2021 anti-bribery recommendation on that front. It did bring an advance, but it really should go further, and I think it would be helpful for them. Thanks.
Gideon, you were referring to judicial review?
Yes.
Yes, okay. Yeah, Nicola Aloka. In that respect, yeah, it would be interesting to hear your thoughts on that. Also, from a business perspective, I'd be interested in, whether you could pick up on what Cornelia said before on, well, sometimes it's difficult so France, for example, debated these negotiated solutions. There are differences in case law versus civil law. I know that sometimes for countries acceding to the OECD, it can be very complicated to I think it's mostly the anti-bribery convention, the things that you have to put into your law because they see it as alien in some ways. So how complicated is that to have different judicial systems and then, you know, well, have on the one hand, and then being a global company and trying to comply with all of this? Does the anti-bribery convention, do other international standards help here? What is the state of play?
Okay, on this, I will get straight to the point, and I can sum up my whole answer in one sentence. So private actors need to be included in government strategies because we can help the governments with the experience gained in the business sector. For the long answer, I will recall two rules of the manifesto. So the first rule is think global and act local. It's with the word global vision. This means that the solutions we need to be both inspired by global standards and adjusted to the peculiarities of local contexts. Of course, with regards to the countries, the global approach should consider both global standards and cultural differences. And to this end, governments should play a key role in terms of promotion and incentives in order to ensure consistent standards implementation across countries and to provide a predictable, what Gillian said, a predictable environment for companies promoting a level playing field. But with regards to the business environment, corporations should use the building block approach, which means that anti-corruption frameworks should be implemented, giving consideration to budget resources restraints. Here I am referring to the small and medium enterprises that in some countries are the backbone of the economy. And in this context, large corporations play a social role. They should share their best practices and solutions with small and medium enterprises and train them to increase their compliance capacity and improve their responsible business conduct. This approach is needed to stabilize the supply chain. Also in this context, governments should play a critical role by defining rules and incentives that stimulate business integrity, resilience and quality, enabling specific solutions, especially with regards to the use of artificial intelligence. And this brings us to the next rule of the manifesto. The rule number 7 is tech for trust and transparency. Technology is a game changer in the fight against corruption. Technology is an enabler of the trust and transparency that Gillian said before. And the technology is worldwide. So we must seize the opportunities of digital compliance solution, because the use of technology in compliance for both public and private organizations gives confidence that public resources are being used responsibly, ensuring the best value for money, but sends a strong message that the critical processes will be clean and fair, so we can assure trust and transparency that are the basis for collective action. We cannot hear you, Nicola.
Thank you, Nicola. And we have our first comment from the audience. We're almost done with our time, but if there are more questions, I mean, the audience has been curiously quiet compared to other events we have, but we can perhaps have a little bit of overtime, because you said interesting things, but I'd also like to pick up on the question or the comment. There's a comment that, well, there's more and more greed and perhaps there's a spiritual problem, so this is difficult to grasp. But since you said, Cornelia, you're going about this problem also empirically, I wonder, do you have data, or do you know of data whether with this, negotiated justice globally, can we say that this has sort of put a lid on corruption, or is it so difficult to assess that we cannot really say?
So maybe I'll say the problem of all studies in criminology is that we don't know what the unobserved number of criminal cases is and how much of it we're seeing now. My intuition, in absence of such data, is that the level of malfeasance and greed in the world is a constant. We will always see people who try to make as much as they can out of activities that maybe they can get away with. I'll make it simple. What I do see is that we've moved into a world where it is harder to get away with a certain amount of activities than it was in the past. I mean, back in the day, centuries ago, companies were called the robber barons that just ran away with the wealth of society. And today we see that we have mechanisms to go after them. And maybe I'll conclude on something that was mentioned, and that is the victims. I think it's interesting to come from the victim perspective to see how far we've gone, because we now have mechanisms that allow us to at least discuss and close cases through some form of settlement, where previously we might not have been able to do that. There's all sorts of things that could be wrong with it, but I've heard in several interviews when I said, isn't the system problematic because you negotiate, people settle, there's money being paid, and then it's as if the crime goes away. And one person answered me, but it gives us closure to at least know that we can address cases and that there can be coordination. Certain corporate criminal activities that are now settled are settled with 3 countries. Think of Airbus participating in a case and coordinating it and settling a case, but that means also settling it and closing it for those that feel that they're a victim of this case. So I think that we have to take into account, we're not in a perfect world. I don't think we're in the best possible just system that we want to get to, but I do think we're moving forward.
Yeah, and Nicola, you're raising your hand, but I did want to hand over to you anyway, because also there was this question from the audience. Yeah, but this settlement-based system, doesn't it give the US an advantage? What I mean, have no expertise in the field, but I have seen it, as I mentioned before, that some countries are really uneasy about this type of rules that are sometimes to be applied also within the anti-bribery standards. So I just wanted to hear, in addition to your comment, I wanted to hear from you, is this a concern sometimes in the group of countries trying to advance the anti-bribery convention? What type of legal system sort of dominates, or basically can everybody adjust more or less?
No, thanks. I think this is really a critical point. First of all, just to pick up on what Cornelia said, I think it's really important. What we've seen is not a race to the bottom. We are seeing a race, I think very gradual, but a race to the top in that respect. We have had major settlements, multi-jurisdictional, involving several jurisdictions. So you mentioned Airbus, could also mention Odebrecht, could mention Trafigura. So we have a host of examples now of major corporate foreign bribery schemes that have been investigated, prosecuted, and sanctioned with billions of dollars of fines down the road. So this is very positive. It means that instead of having, especially at the global level, this sort of a race to the bottom that we see sometimes when it comes to regulation, in that specific matter, we see, on the contrary, a sort of race to the top. So it's positive. As far as the settlement, non-trial resolution type of settlement is concerned, in the group, I think there is now a consensus in the working group on bribery that this is one avenue to explore. It's not the magic bullet. And in fact, the WGB on NTR, so non-trial resolution, has always been very clear that you need a proper articulation of sanctions, incentives, and non-trial resolutions. And this is encapsulated, in fact, in the 2021 recommendation. So you cannot have effective carrots without effective sticks. So it's not to say that dispute settlements, which are non-judiciary, is the magic bullet. And this we need really to strike the right balance. And if you take the WGB, just to pick up on what you said, it's a mix of common law and civil law jurisdictions. And I think this has been the case since the start. So it's true that some jurisdictions, because of their economic might, have a certain influence on the group. And there, perhaps to go back to the crux of Cornelia's book, it's very much a sort of a dialectic process between multilateralism and unilateral action. I mentioned the case of the FCPA, which is a clear one. But think also of tax transparency. Tax transparency, this agenda has made major progress, not problem, but also problems for tax evaders. Major progress thanks to the US FATCA. Without the US FATCA, you would not have broken the resistance of certain OECD jurisdictions, a couple of small countries, which I will not name here, but I'm sure you know which they are. And it was absolutely pivotal and instrumental in breaking the resistance of those countries and to achieve the major progress that then we have recorded in the G20 with the Global Forum on Tax Transparency. And so it's really a combination of unilateral action, legal competition, to use, I think, the one expression from Cornelia, and multilateral action to make sure that it's unilateral perhaps at the start, but then it becomes mainstream in the multilateral system, also bringing in the concerns of other economies and jurisdictions. So it's very much a dynamic process and dialectic. It's not one or the other. This is really the articulation of both that is really paving the way for progress.
Yeah, thank you, Nicola. And we are already past our time, but we are in the Euro Cup at the moment, right? So overtime is a little bit, not too much, but we can have a little bit of overtime. I think we shot many goals already, but perhaps they're you know, give me 2 more minutes, and if you can. Because there's one question, rather a bit more technical, Cornelia, to you, but I would like from the audience, which I would like to pick up on. So basically there's a question on pharma, whether in your pie chart that refers to FDA-related issues. Then there is a question, do you have data on Brazil and Latin America? It wasn't evident. And also, I think in the comparison where you somehow show the home bias, the question is, and I think that's interesting, you know, do the EU companies, do they pay more because of antitrust fines are more common there? And I think that would be interesting for all of us to know.
And let me include also the question by Otto Meyer, and Nicolas in his answer just gave the answer to this. So the question is, how is it in America's interest to reform the current system? My short answer is, it's in America's interest, because if the US only goes with unilateral enforcement, they will be perceived as abusing some sort of dominant position. My colleagues, Henry Farrell and Abram Newman, have written a book called The Underground Empire. If the idea is that here the US uses an economic system to build an underground empire and impose itself, it'll be much weaker than if it can anchor some of these in a dialectic through multilateral rules. And I think that's the motivation. Now, to Ronaldo, you're right, it didn't, Brazil didn't show in the picture, but also Nicolas just gave the case. Odebrecht, of course, the massive, bigger than life corruption scandal that is known as Lava Jato is a very important part of the Latin American history and the Latin American US coordinated history. It doesn't show up in my chart because a big portion of that hasn't gone to the Department of Justice, but actually went back to Brazil. If you're interested in the story, buy my book. There is a chapter on it. It's a long version, but it's extremely relevant for what happened in Brazil and all of the political aftermath as well. Yes, pharma is pharmaceutical labeling and pharmaceutical marketing, and that's something that is relevant in particular in the pharmaceutical market, but also for a lot of US companies. And finally, on antitrust. So I'm not sure I entirely understand the question, but what I can say is antitrust is the one area where the big stick of the Department of Justice exists on the European side in DG competition. And both can try to target non-domestic companies with very similar type of fines. And there are studies that are done not by me, but by other colleagues, in particular somebody called Chase Foster, on the the bias against non-domestic firms in Europe and the US. And I'll just cite it to make it simple. The European fines are much less biased than the US fines, which he, as an author, explains by the bureaucracy of DG competition, which really has very detailed sentencing guidelines, which the US does not. So I agree a lot with what Gillian said. If you go towards non-trial solutions or all of this, if you have judicial review, if you have sentencing guidelines, if you have transparency over what sauce you'll be eaten up with, as the French would say, I'm sure that didn't translate right, but how you will be going through the process, it makes it easier for the companies, it makes it more transparent, it makes it more comparable. And I would encourage all of us to go down this bureaucratic route. I think it will be a better system.
That's a perfect final word, but I still want to ask Anna Maya, invite Anna Maya to comment on that, because Gillian said, oh, I hope that our business partner will be on board with this, and because you represent many German countries, and Nicolas also talked about the fact that, and Gillian did too, that companies from big companies, big multinationals can be an ally helping to enforce compliance in countries where perhaps governance is a little bit weaker. Is that the way to go from your perspective too?
Yes, certainly is this. And I would like to support one statement of Gillian and also one statement of Nicola Aloka that you made, sort of the power of transparency. I think it makes sense to use this power, but it could make sense as well not to use it only in this sort of negative in order to detect name and shame, but also in this positive connotations, because you can celebrate it. You can see that what you can see also in this peer reviews of the OECD. And I think this is the power that the companies are really showing to the staff members, showing that, did you see where we are ranked? Did you see that we managed to go through? So I think this is very important, but also what Nicola said, and just you, Nicola Brandt as well, is that we need to define a new way of dialogue, because just Nicola Aloka said that we need to have this sort of channel to the political decision making, because there are some rules that are impossible to implement. And my question is all the time, where to report this back? Because we do have this very willing, committed companies, and use that. But if you sort of you generate frustration if we are not able to talk about that and to report back. And also in some cases we do have very good and maybe even innovative ideas how to make better compliance and how to get new solutions, but also how to speak with further companies, because the companies love to speak to other companies and not only to politics. And so also in this sense, use us as a channel to business.
Yes, use DICO and BIAC and bring in the business when you make the rules. Yeah, I think I cannot stretch the game any further. I think we brought home many goals and showing that integrity is possible. The OECD is the organization of best practice. And best practice are Reinaldo Goto and Anna Maya, because they're both either ordered Cornelia's book already or they have it on their night table. I think that's what we are all going to do now. And with that, I say goodbye and have a lovely afternoon.
Thank you so much.
Thank you very much.
Bye-bye.